Hello, good to have you back. My name is Mary Imbufe. I'm your host on ER with MI. Today we'll be looking at some very interesting topics. One of them, which is really dicey, is the limitations of the Nigerian labor law. Are there really limitations to the Nigerian labor law? Well, some employers will tell you that as an employee, your contract of employment is more valid than the Nigerian labor law. So once you've signed your contract of employment, that stands for you, above the conditions of the Nigerian labor law. Is that true? Is that false? Well, that's why we're here. That's why I'm here. Well, truly, the Nigerian labor law refers majorly to a class of employees known as workers. So according to the Nigerian labor law, there are two classes of employees. The first class, which is referred to as the workers, are people that do manual labor, clerical staff. You understand that? While the other, classification of employees are called non-workers. Those are like the administrative guys, the executive guys, the operations guys. This is the major argument that every employer has today. They will tell you that the bare minimum as contained in the Nigerian labor law is particularly directed to staff members known as, or employees known as workers, and not those that are classified as non-workers. But they forget something, which is very, very interesting, a very, very interesting part that turns this whole limitation around. And that part is the third alteration to the Nigerian Constitution of 1999. Yeah. So that third alteration, when you look at section 254, I think section 254 part C, something like that. So in that act, we see that the National Industrial Court has full jurisdiction to actually make verdicts on employment-related issues. That means that once this employment as employee-related, employment-related, it is the NIC that has the full jurisdiction. They've been given the authority to make such rulings. And guess what? They are not limited in scope. So they can make such rulings for both workers, non-workers, employees, staff, whatever. Now, what's even more interesting is the fact that the NIC has come out to say that, hey, because we understand that there is something called contract of adhesion, we're going to be using the contract preferential rule to judge our cases. What are contracts of adhesion? Contracts whereby the person that writes this contract have a superior authority over the person that is to sign the contract. So in the case of an employee and an employer, it is a situation where the employer, who's the person that actually drafted this contract, has superior authority and a higher advantage over the employee who signs the contract. The contract of adhesion is like a standard form contract, which is a contract where the dominant party is the one drafting the contract and then the lesser party is just signing. So one party drafts it and the other party just signs without making any input. And we all know that that is literally what happens in the work environment. The employer drafts the contract and it gives the employee on a take it or leave it basis. So now, because the NIC understands that actually this is what happens, okay, so NIC is aware of this and they're saying that in all our rulings, we're going to be using the contra preferentium. Now, what is contra preferentium? Contra preferentium is a situation where, if at all there is any form of ambiguity in that contract of employment, the employer or the person that drafts the contract would have to suffer for the result of that ambiguity. What am I trying to say? So if your contract is or has any clause that is somehow shady as an employer, the NIC may actually rule against you and in favor of the employee. Why? Because they believe that you drafted that contract to suit you. it's a contract of adhesion. So the contra preferential is actually saying that any ambiguity in the contract of employment is going to be used against the drafter of the contract. Now, because the labor law is limited in its classification of employees, and actually infers that the employment letters or the contract of employment works or stands for, for non-workers. And because certain things or certain clauses are not actually discussed in labor law, like paternity leave, the Nigerian Industrial Court is now coming to say that we will rule against any practice or any policy or any law or any contract of employment that is not in accordance with international best practice for employment. Don't forget, they have total jurisdiction to rule on employment matters, and their jurisdiction is to actually function according to international best practice. That means even paternity leave that is not even on the Nigerian labor law is actually included. So if you decide the people of paternity leave and they report the case, I'm sorry, NICN might rule against you as an employer. In my next video, by the way, I'm going to be listing out some very common things we see employers doing that is actually against best practices and that the NIC is actually against. What are international best practices? International best practices are the practices that have been tried over time and seen as the best when it comes to employment. So because they've been tested and tried and proven to be the best when it comes to employee-employer relationship, they are now being ratified by different countries to be used in their own country. So what this means is every employer has to be very knowledgeable of international best practices as promoted by the NIC, which is the Nigerian or National Industrial Court. We're going to be delving deeper and deeper into some very common things that employers do that is actually against international best practices in my next video. And we're not just going to be doing that, we're going to also tackle how to go about reporting these cases, and is it cost effective? How do I get the money to actually run this court case? What do I do? I'm going to be dishing out hot knowledge regarding this matter. So please stay tuned. See you again next week. Not same time, not same day, but next weekend.